2A now. All right, Section 2A, duty for negligence. In general, what kind of duty do you owe? Well, under Andrews, you owe a duty to all people. That's the minority view, but the majority view is you owe a duty to anybody within the zone of danger. Now, there could be statutory duties. What is a foreseeable plaintiff? Anybody in the foreseeable zone of danger. Don't forget, you only have a duty to prevent foreseeable risks of harm. If I'm the owner of lake cabins in the middle of nowhere that people go for peace and tranquility, and there's never once been any incident there, it's not foreseeable that somebody's going to get their property stolen if I haven't had an incident in 30 years. But once something happens, now I've got a duty to prevent foreseeable risks of harm. So if something has never happened, you don't have any duty to prevent against it. Foreseeable and unreasonable risks, don't quite know what they're getting at there. Affirmative duties to act. When do you have an absolute affirmative duty to act? Well, let's say that you negligently caused the harm. Now you have an affirmative duty to render care. What if you innocently caused somebody harm? You weren't negligent. Let's say somebody's running across the street in the middle of the night, and I'm driving the speed limit, I'm doing everything proper, and I innocently hit them. Do I have an affirmative duty to help them? And the law says, yes, I do. Even though I innocently caused their harm and I'm not negligent, I now have a duty. Also, one of the ways you can have a duty is by consent, like usually contract, by statute, or would be another way of affirmative duty. It's slipping my mind. Or if I begin to undertake a duty, I can't leave you in a worse position than I found you. So that's a quick recap of Section 2.